My name is Shady Ogui. I'm here at the Riverside CPS court. I hired attorney Vince Davis to represent me, and it's a good thing I did. I was here today for trial, and Vince Davis got all the charges against me dropped. And he got the children placed with me, and the case closed. I rate him a 5-star attorney.
Good evening. This is Attorney Vince Davis, and these are my office hours. I'm usually on early in the morning, 6:30 a.m., but today I had a very busy day, and so I'm trying to get the office hours in this evening. If you have any questions, go ahead and post them in the chat, and hopefully I will have time to get to them. All right. I want to welcome you back to my office hours. I'm Attorney Vince Davis, where today we're diving into one of the most important topics I've ever covered. And it's the 20 biggest mistakes parents make in CPS cases and how to avoid them. These mistakes can cost you time, cost you your rights, and even cost you custody of your children. But if you know what to watch out for, you can protect yourself and fight smart during your CPS case. Please like, share, and subscribe. If this channel has helped you or someone you know, please consider making a donation to support this mission. Your contributions keep this content free and make sure they reach more families and help more people. Even making a $5 donation can make a big difference. Down at the bottom on the ticker is how you can make a donation to keep this channel going. All right, so let's get into it. The 20 mistakes. Number 1, the first mistake that you can make is talking to a CPS social worker without your lawyer. Never talk to or consult with a CPS investigator without consulting a lawyer. They may seem friendly, but anything you can say can be twisted and used against you. This is what you should say when they try to speak to you. I'm willing to cooperate, but I'd like to speak to an attorney first. You have that right to speak to an attorney whenever a governmental agent is involved. All right, the second one is signing documents you don't understand. Don't sign any safety plans, case plans, or voluntary agreements unless you understand every word. These documents can waive rights unknowingly or imply some type of guilt. Here's what you should do. Always ask for time to review the documents and consult an attorney. Extremely important. Do not think that you know as much as the social worker or that you know more than the social worker. And don't let him or her talk you into signing documents that you haven't reviewed with an attorney. Number 3, failing to document everything. Keep a journal. Save texts, emails, and voicemails. Write down dates and conversations. This becomes powerful evidence later. My tip, use a dedicated notebook or secure phone app. Now, one of the things that people are using these days are AI-generated note takers. You can pull them up right on your phone, and it will transcribe all conversations. It will summarize all conversations, and they're very cheap. So consider using an AI note taker. Mistake number 4, not asking for services or help. Sometimes it's needed. You have the right to ask for parenting classes, therapy, visitation, and CPS must help facilitate those. Don't wait. Ask early and in writing. Mistake number 5, not following the court orders to the letter. Even minor violations can be reported by CPS. Always follow orders exactly. Advice: keep records of your compliance, your screenshots, your certificates, and your attendance log. It will become an issue later in the case, and you must have that evidence to arm your attorney with. Mistake number 6, missing court dates or being late. I need you folks to show up for your court dates. I need you to show up on time every time. Most judges take this seriously. Being late can damage your credibility and your case. Here's the pro tip: set reminders, use alarms, and plan ahead for traffic or parking. Mistake 7, losing your temper. Anger gets documented by social workers, and it will be used against you. Stay calm even when it's hard. Don't yell at caseworkers. Don't yell at the judge or in court. You know, a few months ago, I did a trial in the southern part of California, down in Riverside County. And I didn't represent the father, I represented the mother, but we were on the same side. And the judge was about to rule that the child or the children should be released to the father. And at some point in the case, or towards the end of the case, the father raised his hand and said, "Can I speak?" And before the judge could answer, the father started yelling at the judge and losing his temper. Well, guess what? He didn't get the kids. One of the, I guess, golden rules is never yell at the judge. It's not going to help you, and it probably is going to hurt you. Pro tip: if you get upset, step outside, take a breath, use your support system. Mistake 8, not staying involved in your child's life. Attend every visit, every meeting, every chance to connect. If CPS says you didn't ask to see your child, that's a problem. If CPS reports to the judge that you didn't keep your court-ordered visitation, that's a problem. That alone can be used against you to keep your child in foster care. Pro tip: request all visitation in writing and follow up if they delay. Mistake number 9, thinking you don't need help. You cannot do this case alone. Get legal help. Use community services. Join my Fight CPS School, SKOOL. Use your court-appointed attorney. If you can't afford an attorney to be private attorney, the court will appoint you an attorney that is court-appointed. If that's what you can afford, you need to make the best of it. Do not try to do these cases alone. Remember, this is not just about winning. It's about getting your child home. Mistake number 10, giving up too soon. This CPS judicial system tends to be slow, frustrating, and unfair, but you must be persistent. Many parents reunify with their children weeks, months, and after it seems hopeless. My advice and pro tip is keep fighting. Use your support network. Ask for help. Mistake number 11, allowing CPS into the home without a warrant. This is at the beginning of the case. Even if a CPS agent shows up, you have the right to refuse entry unless they have a court order or there's a clear emergency. Here's what you say. Do you have a warrant? Question mark. Then record the interaction if legal in your state. I've had clients who have tape recorded and video recorded social workers at their home telling them that if you stay, you're going to be recorded. And if the social worker stays, knowing that they're recorded, they know that that conversation is being audio and videotaped. Mistake number 12, not requesting a relative placement. Parents often forget to ask the court or the social worker to place the child with a family member instead of foster care. Pro tip, ask the court and the social worker early and in writing. Provide names, address, and phone numbers, and the relationship of the child and the person you're seeking to have the child placed with. By the way, they don't have to be relatives or even blood relatives. They can be family friends, which are known in the court system in California as NEFREMs, non-related family members. Mistake number 13, assuming CPS will be fair. Many parents assume social workers will help them reunify. That's not always true. Strategy, be proactive, track everything, and consult legal help from day one. Mistake number 14, ignoring court-appointed attorneys. Some parents assume their court-appointed attorney will not help them, and they stop communicating with their attorney. My advice is use that court-appointed attorney effectively or request a new one if there is a conflict. In California, there's a motion that you can file. It's called a Marsden motion, where you can get a new attorney, court-appointed attorney appointed. There are some requirements. I have a video on my YouTube channel about all the requirements of how to make an effective Marsden motion to get a new court-appointed attorney. So look on my YouTube channel for that. Number 15, excuse me, failing to appeal negative findings. You may lose valuable rights by not appealing bad rulings. There are strict deadlines for appeals. My tip, file timely appeals, especially after jurisdiction disposition hearings or the termination of your parental rights hearings. What are those timelines? Well, you're going to have to talk to your lawyer, probably your private attorney or your court-appointed attorney, and find out what those guidelines or those timelines are. Mistake number 16, letting CPS drug test you randomly without cause. This is generally before case is filed. Unless ordered by the court, CPS cannot randomly drug test you. Here's what you say. Is this testing court ordered? I like to consult with counsel first. I had a conversation today about drug testing and the difference between a drug test, which is admissible, and a drug screen, which in my opinion is not admissible in a CPS case in a court of law in California. If you don't know the difference between a drug test and a drug screen, give me a call, 888-888-6582. Number 17. Mistake number 17, assuming visitation is a favor. Visitation is a right, not a gift. You are entitled to it unless a judge says otherwise. My pro tip, ask for a written visitation schedule and document any missed visits. Mistake number 18, not getting a copy of the CPS file. I see this all the time. You, as the parent, have a right to review what's in your case file, including reports and evidence. Talk to your attorney, your private attorney, your court-appointed attorney. Get a copy of your file. In California, consider filing an WIC, Welfare and Institutions Code Section 827 petition to get a copy of your file if your case is closed. Mistake number 19. Taking plea deals in related criminal cases without understanding the CPS consequences and ramifications. A guilty plea in a related criminal case can destroy your chances of reunification. It can destroy your chance of trying to get your child back. Pro tip, Make sure your criminal defense attorney understands CPS implications. I get a lot of calls and from people that are being charged criminally for some type of child abuse, and they also have a CPS case. Um, and they have a criminal attorney who knows nothing about CPS, case law, or procedures, and then they have a CPS attorney who knows nothing about criminal law. The best strategy, in my humble opinion, is to have the same attorney represent you in the criminal case and in the CPS case. But you got to do some digging. You got to make sure that that person knows what they're doing in both arenas. Mistake number 20, relying on a social worker to track your progress. CPS may lose paperwork or not update their records. Don't assume they're tracking your progress. My advice: bring proof of completion to every hearing, copies, logs, certificates. But really, my advice, which I've talked about in the past, is keeping that diary, sending that email after every reunification session of parenting classes, counseling classes, domestic violence, substance abuse. You send that email after every class you attend, after every session you attend, to the social worker, telling him or her the top 3 things that you have learned in that class and how you're going to apply them to your life. You may want to review those with your attorney before you send them, but send them, because at the end of the 6-month period or the reunification process, somebody's going to ask you, or somebody's going to say, hey, Vince didn't learn anything from his counseling course. Hey, Vince didn't learn anything from his domestic violence. Hey, Vince didn't learn anything from his sexual abuse counseling. You get it? But if you've been sending those emails weekly, sometimes 1 or 2 times a week, you are showing the social worker and later the judge, because you can bring those into evidence, that you are learning. The other day I was telling you that I did a case where the judge actually asked my client, hey, what'd you learn in domestic violence? Hey, what'd you learn in parenting? If my client hadn't been prepared for that question, what I see sometimes is a deer in the headlights. They took the class, they really did learn something, but now they're so nervous that they can't regurgitate what they've learned. They can't tell the judge how they're using it in their life. So make sure that you consider that while you're in the reunification process. Tomorrow, I'm going to try to post a handout of all of the top 20 mistakes and what you should do to cure them, on the platform that you're watching on right now, either YouTube or on one of the Facebook channels. So come back, take a look at this, see if that PDF is there. It's going to be downloadable, and you can save it for future reference. As much as I can during my office hours, I'm going to have a PDF, try to have a PDF download, for you to be able to print out and take a look. All right. It seems every one of these mistakes play out. The good news is now you know better. You have the tools to avoid these traps. If you're facing CPS, don't wait. Get informed, get help, and don't do it alone. One of the things that you can do is join my Fight CPS School, SKOOL.com. It's just $10 a month, and it could save you time, energy, money, and your children. And if you believe in this mission, again, consider donating. Your support helps parents fight back. It helps them access real legal knowledge, and it keeps this channel alive. Visit the link below on the ticker tape, and please contribute. I am attorney Vince Davis, and thanks for watching this session of the office hours. Before we go, because we do have some more time, I'm going to try to take some questions here. And yes, office hours hopefully will return tomorrow at 6:30 a.m. Pacific time. Okay. Cruel Ladatic. Trick Says, good evening. Good evening. Christina, if the court makes the children a sibling set, how can they allow one to be adopted and the other remain in foster care? Christina, that's a very good question. Unfortunately, it happens all the time. That's a philosophical as well as a legal discussion that would take up a whole show, but it can be done. Cruel Dotrick says, my rights were terminated in 2024. Sorry to hear that. Let's see, but I lost my appeal, not surprising, as I had access only to court-appointed representation until current. The social worker's case reports did not include very relevant details about the chain of evidence that transpired throughout my reunification services as well as during my transition to permanency. Social worker. I believe today is the day a remediator is filed. I don't know what a remediator is. Okay, so this is a remediator. A remediator is a statement issued by the Court of Appeals to indicate the decision that they have made is final. Okay, once it becomes final, there are steps that you can take to further appeal or seek a writ to a higher court, but you must talk to your attorney, your appellate attorney, about that. Akima says, good evening, Mr. Davis. Yashua Savior, Attorney Vincent Davis, thank God. Akima says, I just received a new case planner, and he wants to meet with me on Monday, which is literally 2 days before the next court date. And this was sent via text message and email. Okay, well, Akima, you know you should be talking to your lawyer. Lucky Dad says, thank you. And Cruella.Trick says, I think maybe my court-appointed reps didn't submit into evidence all of the documents I provided to them prior to our hearing dates. Distinct possibility. I hear that all the time. Just talking to someone about that today. Cruella.Rick. Got it. All right. Yashua says, everyone, Attorney Vincent Davis, such a great blessing to us all. Take good care of him. Thank you, Yashua. Take advantage of his live show, but wake up at 6:30 a.m. Yashua says, this is the best background, sir. Akima says, my retained attorney is on maternity leave, and the one assigned to me has not been accessible since the last court date, January 6th. Akima, that's not good. I remember I talked about that on your show the other day. Not good. Maybe you can talk to some of the higher ups and the supervising attorneys at your law firm so that you can get someone that you feel is competent enough to represent you during these court proceedings while your attorney is on maternity leave. Okay, everyone, thank you for watching. We'll see you again tomorrow, 6:30 a.m. Everyone be safe. Bring your questions with you and post them in the comment section. I'll try to do some Q&A at the end of every office hours. Alrighty, good night all.
When I was interviewing attorneys, one of the attorneys told me Vince David was retiring and he didn't know what he was doing. That was a competitor of Vince's. I knew the part about Vince not knowing what he was doing was false because I had seen his YouTube channel. That attorney that told me that was a competitor and a liar. Vince Davis was masterful in the court.